Hello, so I'm going to be doing a set of videos on contract law, which is basically the fundamentals of law as well as economics and many other disciplines. So in this video, I just want to introduce what I hope to be doing in my set of videos while looking at contract law. So basically, contract law, as the name would suggest, centers around a contract which consists of three different components: the offer, acceptance, and then the consideration. Now, I'll have videos on what these are, why they're important, and different theories relating to these as the videos go on. But that is basically the kind of fundamentals within which all the videos on contract law and the whole discipline centers around. So OAC. Now, invitation to treat. Basically, that is like an advertisement, or it's just a mere puff. It's kind of it can lead to a formation of a contract, but it's more like it's just a signal saying, an invitation saying, this is what I would like to do. So it's like when you see an ad in Glamour magazine for Dior lipstick. It's not a contract. They haven't been offered it and you haven't accepted, and there hasn't been a consideration. It's just an invitation to treat. It's just saying that this is available there, and it might lead to a contract because I might go out and purchase this. There might be a sale of goods and there might be a contract. So when I want to talk about contract in my videos, I will talk about like in a sort of triangle. You have the offer, you have the acceptance, and then you have the consideration. So it's like a triangle. And then from the offer, I would put a dotted line and have the invitation to treat. So I'll make an image of this on the Mac or something, and then I'll upload it so you can see this is the kind of structure of how I perceive contract law and how I want to center my videos on contract law about. So in this video, what else do I want to talk about? Well, I think it's important to understand that there's two different understandings of what is a contract and just contract law in general. And one is a relational understanding and one is a discrete understanding. So what's the difference? Well, contract law started forming in the medieval century. I think it was more actually 17th, 18th century when the formation happened, and we called that the fundamental of contract law then the classical contract law. Now, then the classical contract law had a discrete understanding of what a contract meant. And what I mean by discrete is it's merely what one person gives, what the other one takes, and what the other one gets in return, and that's kind of it. So I'll give you an example. An example is the best way to explain this. You can look up precise definitions. You don't need me to say them. I'll just give you an example. A discrete understanding of a contract would be: I offer to sell you this pen, you accept my offer, I consider it and then accept it, and that's the end of our contract. You're basically only focusing on the actual trade or the actual give and take that's going on. If we have a relational understanding of a contract, that means you include all the other things that are going on at the same time. Who has a greater bargaining power? Is someone under the influence of somebody else? If I sell this pen and they take it and it leaks on top of them and they get ink poisoning, has the contract finished, or is there some other kind of moral duty, a duty of care associated that we should link in? So relational is a much more long-term, airy-fairy, whereas discrete is basically the trade, the give and take that has happened. Now, why it's important to understand these two different understandings of contract law is because they underlie the different approaches that judges take. And judges take basically a range of different approaches. So I'm going to mention basically three. There might be an economics approach where basically you just look at the costs and benefits to each party involved in the trade. And that kind of approach to looking at a contract is a relational approach, because you look at also the long-term costs and benefits to a party, not just the short-term that were there when you signed the contract. It's when you took the good home, for example, Did it explode? Was it good quality? Was there another duty associated? So the economics is long-term as well as short-term cost and benefit. And because it's also including the long-term, it's a relational approach. Judges might also take a social-political approach. Now, this can be divided into two, one which is discrete and one which is relational. So if we look at the relational one again, it's the socio-political approach focusing on consumer welfareism. So it's looking at fairness, who has a greater bargaining power, how can we protect the little man. That is what this approach to a contract looks at. It looks at who is actually more in power, and how can we do positive discrimination to make sure the weaker person does not lose out, or in any case we're not unfair. And this is relational because you're looking at issues which are more than just the give and take, whereas the discrete socio-political view is a market individualism view, which merely looks at the give and take because that's the end of it. And in some ways, this market individualistic approach is good because it ensures certainty and all these, certainty. That's the key thing it ensures, which is very important in terms of economics, growth and economic trade, things like that. So what the tension that exists in contract law today, we will see, is we live in a common law a legal system where judges, they look at precedent, but also they look at what is the common customs that are happening here now today in the world. And the problem is, here now today in the world, we're in a consumer welfareism economy. We have the welfare state, we have the NHS. This is our social understanding, environment, and our background. Yet contract law is based on principles of classical contract law, which were based on a discrete understanding of a contract, a market individualistic view. And because of this, basically, there is a tension of judges of how to balance this out. And this is where, contract law doesn't suddenly become as clear-cut as, well, this is what happened in case X, so Y is going to follow the same thing. But we can kind of know, from just generally understanding law, that it's not so straight and easy to understand. That's why we have lawyers. And I want to finish this video by introducing quickly the concepts of freedom of contract and sanctity of contract. So let's start with sanctity of contract. Sanctity of contract, basically, if you have done philosophy, you'll understand the argument of sanctity of life. Sanctity of contract is very similar. It's all about protecting, respecting, and making sure under no cost is that contract broken, because when it's broken, you lose the religious sacredness kind of thing that is associated with that contract. So like in sanctity of life argument, you don't want to kill yourself, we don't want abortion, we don't want to do these things because they undermine the value of life. So just like this, you undermine the value of a contract. Freedom of contract, well, we can look at it in two ways. We can look at it as the freedom to contract and the freedom from contract. So we're looking at the freedom to go into a contract under no duress and things like that, and the freedom to negotiate terms and things like that. Now, there's no clash between a freedom from contract and standard form. And by standard form, I mean contracts such as receipts and basically pre-set out contracts, pre-set out terms and conditions, which there's no negotiation. Like when you go to a shop and you get a receipt which says you can refund or exchange something in 28 days, you don't sit there negotiating that, it should be 14 days. It's already set out. Now, there's no clash because when we have our OAC, the negotiation isn't sort of a fundamental part of it. It might be a part of it, it might not. It's not part of the OAC, which is very, very crucial. That is offer acceptance and consideration for a contract. So when we look at freedom of contract, don't assume that it doesn't exist today, because our world today is built around standard form contracts. Anyway, thank you for watching, and I hope this is a good introduction to contract law.